In your Texas divorce case, one of the things that will get addressed if you're a parent is what's going to happen with the custody, possession and access, and money stuff as it concerns your children. And the main thing you need to understand is that the Texas court is going to be focused on the best interest of the children. When we're in law school, we hear that phrase over and over and over again. What's in the best interest of the children? And that's going to be the overarching concern of any judge in the state of Texas in your divorce or custody case. In Texas, when it comes to custody, you're going to want to understand the difference between what some people call legal custody and physical custody. Okay, first, let's talk about legal custody. Usually, if people are asking this question, what they're referring to in Texas is really conservatorship. And there's a presumption, think an assumption, in Texas that two parents will be joint managing conservators of the children at the end of your divorce. And with this joint managing conservatorship comes a bundle of rights to make decisions about the children. Shorthand for this is decision making about heads, meds, eds, about their medical decisions, school decisions, and psychological decisions. And so if you're joint managing conservators, the presumption would be that's best for the kids, and you would have equal decision making rights in those areas about the children. Now, this is separate from the way physical, like actual custody of the person of the children plays out. In Texas, that's talking about a possession schedule. And so you may have equal and joint rights to make decisions, but unequal parenting time and possession of your children. So even if you can make all the decisions for them, you may not have them the same amount of time as the other parent. When people ask about a parenting plan in Texas, usually I know they got that term from perhaps somewhere on the internet or watching a movie. What they're really referring to is how's it going to play out the care and custody of these Texas children after the divorce is done. And I'll tell you this, Texas has a default that if all things are equal and it's just up to the court is likely to get applied. Or you can agree with the other parent for something different. Now, let's talk about the default. The default that's presumed to be in the best interest of the children, according to the Texas Family Code, is an expanded standard possession schedule. And that's the one you're probably familiar with, that allows the person who's not the primary parent to have possession of the children the first, third, and fifth weekends of the month, during the school year from Thursday when school lets out until Monday when school resumes. And the shorter weekends in the summer, you also would have extended time in the summer for likely 30 days of possession time with the children. So if you're not sure what to do or you just go to court, the most likely outcome is some version of an expanded standard possession schedule for you and your family. Now, one thing we know in Texas divorce and custody cases is that you can agree to pretty much whatever you want unless it violates public policy in some way, but you're not going to do that. You may come up with schedules like a 50-50 access schedule, like something week on, week off when the kids go back and forth. Or you may have even more restricted time, like one of the parents only has the kids on Saturdays every month. Or if one of you is perhaps a firefighter or a policeman or one of our armed service members, you may have an entirely different schedule. So there are some defaults, and then there are agreements you and your co-parent can make so long as, in general, it serves the best interest of the children in your Texas divorce or custody case. The prevailing legal standard when courts are analyzing what to do in a Texas divorce and custody case is the best interest of the children. And you probably may ask and think, what does that even mean? It's a good question, and it varies a lot depending on what court you're in and what judge is presiding over your case. But I think you can take a step back and just use your logical brain of what makes sense. We want to make sure that kids are safe, that they're well fed, that they're taking the medications they need, that they're supported in their education, that they have strong psychological and emotional bonds with their caregivers, that they're members of their community, and generally speaking, psychologically, emotionally, and physically thriving. So the court's going to be trying to figure out, okay, how can we make sure that these children are thriving, and then look to the specific facts of your Texas case to see what would be in the best interest of the child in your given set of circumstances. If you have children and you're going through a Texas-based divorce, I know the number one thing on your mind is likely, how much time will I spend with my children after this divorce or custody case is complete? And Texas has a default schedule that you can use as a guide so that you can understand what's likely to happen in your situation. Now, remember, you and your co-parent can agree to anything that you want, and this default is in the Texas Family Code to give you a sense of what is likely to happen if you go to court in your situation. And that schedule works like this in general. One parent has the children the first, third, and fifth weekends of the month, and during the school year, they would have them from Thursday when school lets out until Monday when school resumes, switching off holidays throughout the year, the major ones like Christmas, Thanksgiving, spring break. And they would get extended time with the children during the summer. The default is for 30 days in the month of July. The parent can elect to break that up into 2 different periods when the kids are out of school if they do so following certain date deadlines as laid out in the Texas Family Code. So if you don't agree to something different, the Texas Expanded Standard Possession Schedule, as lined out in the Texas Family Code, will likely be the schedule that is awarded for you and your family, where one parent has that schedule and the other parent has all the balance of the rest of the time. Custody arrangements can be modified after a divorce in Texas, but it is not easy, and it is not something you want to count on being able to do in making your custody agreement in your Texas-based divorce. The standards are high for post-judgment modifications of custody agreements. If a parent does not follow the court-ordered custody agreement in their Texas divorce decree or custody orders, there are 2 things that can happen, and I want you to think about this in terms of legality and reality. As far as the law is concerned, if you don't follow court orders, you can get in big trouble. The other party can file what's called a motion for enforcement, pointing out to the court your violations of your agreements or the court's order as it concerns custody. And they can seek sanctions such as even putting you in jail or making you have less time with the children. There are lots of options in addition to seeking attorney's fees. So that's what's legally possible. In reality, I would tell you to consider the severity of the infraction. If the parent is 10 minutes late to pick up or at a custody exchange, it's not likely the court is going to put them in jail and award attorney's fees, even though you have a technical violation. Probably what would happen in that instance is literally absolutely nothing. It would be a drop in the bucket of a pattern of ignoring court orders that you might someday use in your Texas custody modification case. But in general, you would need to consider the severity of the breach. For instance, if the one parent did not return the children after their time in the summer, a court would likely get involved ordering the children to be returned with a pretty heavy hand for how they respond with the other parent unless there's some really good reason that they didn't return the children. So you need to be very careful if you already have orders in place regarding custody in Texas about your children, because there are significant potential consequences for violating those orders. One of the number one questions parents ask in their Texas divorce or custody case has to do with child support. And much like everything else in family law, there are two options. Number one, you can agree to whatever you want with regard to child support, pretty much with your future co-parent. You can agree to some set amount of money, that someone pays school tuitions as support. There are lots of options, and you're really limited by yours and your lawyer's creativity. Well, and your agreement can't be against public policy as defined by the judge. That doesn't usually come up in that situation. However, if you can't agree and you're getting divorced or filing this custody modification for a reason, so that may happen, then Texas has some guidelines in the Texas Family Code that deal with child support and give you a rule of thumb of what is likely to happen absent an agreement between the parties. And the way that works is you consider the number of children that are before the court and the net resources of the parent who will be paying the child support, and you do a math problem. Here's how it works. Let's say, for instance, you have 3 children before the court, and those are everybody's only kids. Then there's a corresponding percentage to the number of children. 3 kids would be 30% if the court did it in the default way. And then they take the net resources of the other parent, multiply it by 30%, and that equals your child supported number, on top of which you would typically add the cost of health insurance as a reimbursement, or the party paying the child support has to cover that cost of health insurance. Now, one of the things that I think is a little bit difficult to wrap your mind around if you're not familiar with this area is what it means to have net resources. It's not the same thing as net income. You're used to thinking probably of net income, and that's what money is left at the bottom of your paycheck every other week at work. So you take the gross amount, you remove health insurance, AFLEC, 401k contributions, maybe union dues, a 401k loan, and then you have this number at the bottom. That's your net income. But that's not how a Texas court would figure out the numbers. Net resources are more so gross amount of income that you make, less some taxes stuff, figure out a little bit about the health insurance you have to provide. That's your net resources number. More than likely, it's a bit higher than your net income number. So people usually seem a bit surprised by that fact. And the other thing that you may not know is that net resources are capped for consideration of child support. The way that works is once you start to make about $130,000 to $150,000 a year, after that, your child support will not continue to step up because there's a limit. What that means is a billionaire would pay the same amount of child support as someone who makes, let's say, $150,000 a year. May not feel the most fair. That's something to take up with the Texas legislature. But what it does is give you a pretty firm rule of thumb of how child support will be calculated in your Texas divorce and custody case.